today for a final pretrial conference in this case ahead of a trial scheduled for June 20th and 21st. We are proceeding today partially in person and partially by video conference. First, let me have the attorneys place their appearances on the record, beginning with Ms. McClure.
E.B. McClure filling in for prosecutor of record Isaac Sneed.
Samira Hennigan on behalf of Donald Lester.
All right, and Mr. Lester, I believe, is in the jail Zoom 2 device. Mr. Lester, are you there?
Yeah, I'm here.
All right, so I don't know what's going on with the camera. We can't see you. It looks to be shooting
I can see you.
Almost. I'm saying that we can't see you, Mr. Lester. So, Ms. Hennigan, where do we stand? Are we ready to proceed to trial on June 20th?
Thank you, Your Honor. I met with my client yesterday and did make the final offer to him with regard to plea agreements. My client has declined to accept the plea that was offered by prosecution. I also was informed by my client that he has filed a few motions. I guess you would say pro se. I have not seen those motions myself, but he says he mailed them to the court. He does have many objections to the proceedings. That being said, the next step that would be appropriate with regard to our legal procedures would be to go forward with trial. I am prepared to do that, though I do believe that my client will object to that, Your Honor. So I do want to make sure that I represent his wishes as well, while I still inform the court of whether or not I'm ready to proceed. So I will be ready to proceed for trial next week. That being said, my client does not want to go to trial as he feels that the court doesn't have jurisdiction over him on this matter. For him, that he was upset that I agreed to a trial schedule at a past hearing. And I did try to explain to him that that's just a procedure, that the court is on timeframes according to statute, and that at some point we do have to set a trial schedule, even though it was my intent to continue to try to negotiate this case for him along the way.
All right, to the extent that there's any objection based on court's jurisdiction, I
can't hear you. Can you speak up, please?
To the extent that there's any objection to proceeding to trial based on the court's jurisdiction, I would deny that, as the court does have jurisdiction over this case. It is a felony case involving an alleged felony which is alleged to have occurred within Lenawee County, state of Michigan. This is the circuit court for the Lenawee County, state of Michigan, and therefore jurisdiction is appropriate. Ms. McClure, is there anything we need to address from the people's side?
The people have not received any motions that have been referenced, but as far as I know, we are prepared to proceed to trial next week as well.
Right.
All right, so do we have proposed jury instructions and voir dire questions yet?
We do not. I know I spoke with Mr. Sneed yesterday, but I'm certain that we can agree upon those within the next day or so.
Right.
I see some in our file, so maybe he's drafted them and just not.
Yes, he was working on them.
Okay, so I'll need those by the end of the week so that we have an adequate amount of time to get prepared for trial.
I would also like to intervene here real quick.
All right, before we dive into this judicial roller coaster, let me set the stage, because this isn't just any courtroom update. This is the dramatic return of a sovereign citizen who previously managed to talk himself into 93 days in jail in under 2 minutes. Yes, you heard that correctly. Some people collect vintage action figures. This guy collects contempt charges like they're Pokemon. In today's hearing, we're entering the world of pretrial chaos, where the court is just trying to schedule a trial like normal human beings, and our defendant, Mr. Lester, is trying desperately to prove he's a free-roaming citizen of a mystical land where laws don't exist, judges have no authority, And somehow everyone owes him an
On
apology.
that, I just read that not too long ago, and they arrested me for an old traffic ticket. Is where it started at. They're trying to dodge the point of where they harassed me for 3 days before they arrested. And as far as this possession situation go, I was informed yesterday by my attorney, who I haven't talked to since March, that I was looking at 14 years. Under your court, Michigan rules that after 10 years, under a lower felony, after 10 years, it's automatically expunged. So I'm trying to figure out how am I being charged with a habitual criminal. And also, I would like to get that in writing that you said that you have jurisdiction over this case.
First red flag of the day. And honestly, it's almost poetic. The judge calls for Mr. Lester, and surprise, surprise, he's on Zoom, but he's not even visible. Now look, technical issues happen, but with sovereign citizens, this is practically a ritual. If there's a way to make things harder, blurrier, more chaotic, trust me, they will find it. That camera being pointed at the ceiling? That is the sovereign citizen equivalent of showing up to court in full medieval armor. But notice the judge's tone, calm, polite, trying to keep things professional. Meanwhile, you just know everyone watching is thinking, oh boy, this is going to be one of those hearings. And spoiler alert, yes.
Everything that I sent over there. So there should be somewhere in y'all file that y'all should have it.
Your Honor, I did.
And personal. And like I said, I haven't talked to this woman since March. She told me that I was going to be released out for bond, and I haven't heard anything from her since then. I wrote her a letter. The first time I seen this woman in about 2 or 3 months, his first time was yesterday. And she doesn't represent the said name anyway. I've talked to her about that situation too. Somebody's not being truthful here. And I've been sitting here almost 10 months without a bond or even so much as calling my witnesses. She's never asked me anything. So my due process is being violated. Also, I'm sitting in here on an unsigned warrant. Unsigned. A probable cause warrant. They trying to make it look like they arrested me for those charges, and it's not what it was for. That's not what it was for. I was arrested for driving on a suspended license from back in 2016. That case got dismissed.
Your Honor, I did inform him
He's not
yesterday.
addressing none of those issues, Your Honor. Period.
Mr. Lester, I need you to stop interrupting people, okay? What is it that you wanted to say?
I did inform him yesterday that the charges he was facing could, that it's up to 14 years because there's consecutive sentencing available on those charges. He has a felony that is up to 10 years and then 2 R&Os.
This is a classic case of an attorney trying to walk a tightrope, represent the client, follow procedure, and avoid getting dragged into fantasyland legal theories. Meanwhile, Lester is probably sitting there thinking he's about to deliver a supreme court-level revelation. Spoiler, he's
a habitual offender notice, and he asked me about that yesterday, and I reiterated again yesterday that is not why. That is not why he's facing that amount of time. It was simply me telling worst case scenario in this matter.
All right, so to the extent that personal jurisdiction issue has been raised in addition to subject matter jurisdiction, I'd again deny any request on those bases because the court, again, has personal jurisdiction over Mr. Lester, who is a human being located in Lenawee County, Michigan, and alleged to have commit a felony crime in Lenawee County, Michigan.
How did I commit a violent crime?
With respect to the argument that Mr. Lester made regarding the right to resist an unlawful arrest, that's why the court is having a trial. One of the elements that the prosecutor needs to prove in a resisting and obstructing case is that the officers were on duty, acting lawfully, and made a lawful arrest that Mr. Lester resisted. So that's the purpose of the trial. With respect to any issue about expunged convictions, we're not even to that point yet. The habitual offender issue comes into play only after a conviction has entered, and then the court has to determine whether the convictions listed in the habitual offender notice in fact happen and can appropriately be used under the statute for the sentencing enhancements that have been notified in the information. And so,
Okay. So
Yeah,
whenever you get done, I'd like to address issue 2, please.
all right, I'm going to mute Mr. Lester because I can't have people talking over me while I'm.
This moment right here is what I like to call the judge's deep breath explanation. The judge calmly, almost surgically, lays out the exact reason the court has jurisdiction. The crime allegedly happened in this county, in this state, and this is the court that handles those cases. Boom. Done. Law 101. But what's fascinating is how often sovereign citizens think this is up for debate. It's not. Jurisdiction isn't a vibe. It's not an I don't consent situation. It's a legal fact determined by geography and statute. The judge shuts this down swiftly, and you can almost feel him bracing for what he knows is coming next. A monologue from Mr. Lester that nobody...
Trying to create a record. All right, so then we are ready to proceed to trial on June 20th. Again, I'd like to have the voir dire questions and jury instructions ready or to the court by the end of the week so that we can have those ready to go.
Thank you, Your Honor.
Yeah. Before we go, can I address
Ms. McClure, can I just understand from you what that final offer you made on this case, or what the final offer the prosecution made on this case was?
Yes. It would be.
Ms. McClure, I actually have a copy that I could pass to the court too, if that's okay with you.
Yeah, I mean, we'll just take a second. It's an added count 4 possession of meth in a park, which is a 2-year offense. And we were offering
The case, if Mr. Lester were willing to plead guilty to possession of methamphetamine in a park, that's a 2-year maximum possible penalty, but the prosecution has also agreed to credit for time served or fines and costs, and a personal recognizance bond release until the date of the sentencing. Is that all accurate, Ms. McClure?
How is that? That
Yes.
is crazy.
Yes,
All
that's
right.
accurate, Your Honor.
And Mr. Lester is not interested in agreeing to that plea. Is that correct?
It's my understanding, but it seems that he would like to say something about it, Your Honor, so I prefer that he answer that question himself.
Yeah, I would like to say something because of the fact that you keep trying to let me out on a PR bond and you want me to come back to court for sentencing, but you won't let me out to try to get my witnesses and gather the evidence that I need to be able to present it at trial. I haven't even went over this one. I haven't even went over any kind of defense with this woman. I am being prosecuted and persecuted by her and a prosecutor. And it's obvious. It's very obvious. It stands out. I haven't talked to this lady since March. And when I did, she came in there.
Okay, this is where the train officially leaves the tracks. In the span of about 90 seconds, Mr. Lester references personal jurisdiction, subject matter jurisdiction, unlawful arrest, Supreme Court rulings, harassment, expungement law, habitual offender status, unsigned warrants, due process violations, witnesses, and the existence of the letter S in his attorney's name. It is a lot. This is the sovereign citizen brain in full bloom, mixing partial truths, misunderstood terms, irrelevant details, and conspiracy-adjacent accusations into one chaotic legal smoothie. What's most striking here is how confidently he delivers information that is either wrong, unrelated, or has already been explained to him. And you can